Welcome back. As part of efforts to strengthen the nation's fight against corruption, the president of the Center for Socio-Legal Studies, Professor Yemi Akisheye-George, is advocating the speedy trial of high-profile corruption cases. At a forum with civil society organizations in Abuja, the FCT tagged NGOs and media interactive meeting on measures for fast-tracking high-profile corruption cases. Professor Akisheye-George applauded the Chief Justice of Nigeria for establishing the Corruption and Financial Crimes Trial Monitoring Committee. The Center for Socio-Legal Studies was instrumental to the drafting of the Administration of Criminal Justice Act of 2015, and the groups believe the Act has done a lot to speed up cases.
Olusemetu's case took 18 months from the trial to the Supreme Court. The determination of the preliminary issue on whether or not he has a case to answer. It took 18 months. If it had been in the past, that case would go on for 5, 6, 7 years because of the abuse of interlocutory applications and interlocutory appeals. And the position we've taken at the center is that Section 306 of the Administration of Criminal Justice Act, which prohibits the stay of criminal proceedings, is not unconstitutional. Prohibition of stay of proceedings does not affect the right of appeal. The right of appeal. In other words, the defendant is at liberty to go on appeal. His constitutional right of appeal is not abridged. All that the provision is saying is that you can no longer delay the trial. The trial will go on while the appeal is progressing. And the question has been, what if the trial is concluded and then the judgment comes out in favor of the defendant? We have said that is not a problem that problem cannot be addressed by Section 306. What we need is a proactive appellate system. A proactive appellate system such that when a case that is being tried, when an appeal has been taken from a case that is being tried, the Court of Appeal will be proactive in constituting special appellate panels to determine issues which can affect those the substantive matter. I think that our court system is a unified court system. We have a unified judicial system. The Supreme Court takes care of cases from all parts of the Federation. Court of Appeal the same. So the court must be aware that certain cases, certain trials are progressing in the trial court. If an appellate process is going to delay those cases, there is no reason why the heads of court cannot quickly constitute special panels of such courts to determine such matters, such that substantive matters can progress, will no longer be delayed, as has always been the case.
The center, members of civil society and the media present also dissected the interim report of the Corruption Trial Monitoring Committee and stressed the need for civil society organizations to stand on the part of justice rather than take sides with politically exposed persons.